Yes, Mr. Happy.
My Lords, while this is very trite, it's important to be clear about what this application is and, more importantly as well, what it is not. As my Lords will be aware, this...
You're competing against...
Yes.
So...
I'll try to project.
Yeah.
My Lords, obviously this application is founded on a cause of action for infringement of a UK patent. The allegation is that Ericsson has, within the UK and without Lenovo's consent, supplied equipment which falls within the claims of that patent. And the relief claimed is relief for infringement of that UK patent. And the application seeks an interim injunction to restrain acts in the UK which Lenovo alleges are infringements of that UK patent. And my Lords, we've looked at it already, but maybe we can just get out the draft order from the supplemental bundle, tab 5. And we see that in paragraph 1 of the draft order, until final judgment in the claim, which requires a trial of infringement and validity, we are restrained from doing certain acts within the UK in relation to equipment operating in accordance with the 5G standards, and then they add, or any other product that falls within the claims, as my Lord Justice Arnold's already mentioned, that in itself is probably inappropriate as an interim stage. But the nature of the injunction sought is clear. It is an injunction to restrain alleged infringements of the UK patent.
Well, to be precise, it's to restrain acts which are alleged to infringe.
My Lord is correct. Is right. It is restrain acts which are alleged to infringe acts in the UK, and the basis on which that injunction is sought is that those acts are alleged to be infringements of the UK patent. It's perhaps a more accurate way of putting it. Now, that is the injunction which Lenovo seeks. It did not ask the court to grant an anti-suit injunction or any other form of relief. It asked and asked only for an interim injunction to restrain acts which were alleged to be infringements of the UK patent. And so obviously Lenovo needed to persuade the court to exercise its discretion to grant such an injunction. And as the judge recorded at paragraph 27 of her judgment, it was common ground that the court should exercise that discretion applying the American cyanamide principles. And we needn't turn it up, just for my Lord's note, paragraphs 28 and 29 of Malone Friend's skeleton before the judge, which is in the supplementary bundle at tab 2, made it clear that the principles to be applied were those set out in American cyanamide. And of course that meant that Lenovo needed to show that damages would not be an adequate remedy for infringement of the right on which it relied, its UK patent. To use the words of Lord Diplock in American cyanamide, the question is whether Lenovo would be adequately compensated by an award of damages for the loss it would have sustained as a result of Ericsson continuing to do what was sought to be enjoined between the time of the application and the time of the trial. Because, as Lord Diplock explained and the judge recorded in her judgment at paragraph 29, the purpose of interim relief of this type is to protect the plaintiff against injury by a violation of its right, for which it could not adequately be compensated if it were to succeed at trial. And then, of course, if Lenovo got over that hurdle and succeeded in establishing that damages were not an adequate remedy for infringement of the UK patent, or Lenovo needed to show that the balance of convenience lay in favour of granting an interim injunction. But of course, as we know, the judge held damages would be an adequate remedy for Ericsson's acts alleged infringements of Lenovo's UK patent, and as I'll explain a bit later, we say that she was right to do so. But of course, Lenovo doesn't actually want the interim injunction it's asked for. It doesn't actually want Ericsson to be restrained from supplying 5G compliant equipment to the UK market pending trial. No doubt, it is terrified of its potential liability on a cross-undertaking's damages because of the damage that would be caused to Ericsson and any third party notified of the injunction, for example, the mobile network operators. That damage, while extremely hard to quantify, would be enormous. And presumably that is why Lenovo has never made any serious attempt to suggest that damages under a cross-undertaking would be an adequate remedy for Ericsson. Nor has it made any serious attempt to suggest that any damages due to Lenovo for Ericsson's alleged infringements would not be completely swamped by the harm that would be caused to Ericsson by being restrained from supplying 5G compliant equipment in the UK pending trial. No, Lenovo doesn't actually want the interim injunction it's asked for. What it really wants is for Ericsson not to pursue injunctive relief against Lenovo anywhere in the world. But it didn't ask the court to order Ericsson not to do so. It made it clear before the judge that it was not seeking an anti-suit injunction. And rather, the way it seeks to achieve that result is by the back door. And we see that from paragraph 2 of the draft order, which you hopefully still have open. And that, of course, sets out 3 conditions under which the interim injunction would not apply. Now, my learned friend says, and he made a lot of this, that this scheme mirrors the approach to final relief under the Unwired Planet approach. But even if that is so, just as in Unwired Planet, the first question which the court has to consider is whether the claimant has established that there should be an injunction in the first place. When one's considering a final relief, of course, you have to show that you have a valid and infringed patent. At this stage, you have to show that you're entitled to the injunctive relief because you satisfy the conditions in American Cyanamid. And we say that they don't, for the reasons the judge gave, and which we will support in my submissions as I come to them. Now, there is my learned friend mentioned this, there is a point about the clarity of these provisos arising out of the words in each 2.1 and 2.2 about in the terms that the claimants have offered the defendants in the English Fran proceedings. It's not clear what those are reference to, or indeed to what those words attach. Do they attach, for example, in 2.1 to the words about the global cross license at the start, or do they attach to the words about not seeking any injunctive relief? It's not at all clear.
The wording is not perfect, but my understanding is that the intended sense is that until determination of the terms of the brand license, in the interim, the operable terms will be those that they have offered.
My Lord, obviously that is not my main point on this appeal, but there is a point of clarity as to the wording of 2.1 and 2.2. But obviously our main point is that one doesn't even get to considering the wording of those provisos. The general idea, as my Lord says, is clear, in this sense that the first proviso is an attempt to achieve, as the judge put it, anti-suit relief by the back door. Now, my learned friend said this morning that what he's seeking has some characteristics of anti-suit relief, but also it does not have characteristics of anti-suit relief. And in fact, what that really reveals is that what my learned friend is trying to do is to achieve the effect of anti-suit relief without even trying to satisfy the conditions for it. And that's the point that the judge made. Obviously, 2.2 is about an interim cross-license, and I think my lords have already picked up that in the parallel proceedings under the number that ends 036, Lenovo have sought a declaration that a willing licensor or unwilling licensee would enter into an interim license on certain terms, and they haven't yet established that right, or that proposition. Their claim for such a declaration is due to be determined in a hearing at the end of October this year. So in other words, at the end of next month. Yet what they're trying to do here is to achieve a similar result to what they're seeking in those parallel proceedings, again, by the back door and without having established their entitlement to such an interim cross-license. So all of this is an attempt to achieve by the back door, something either they haven't tried to establish their right to, in other words, an anti-suit injunction, or something which they're trying in another place to establish their right to, but haven't yet succeeded. And all of this amounts to what the judge rightly called, we say, an interim injunction in terrorem. It wants Ericsson to be, in effect, held hostage. It wants Ericsson to be faced with the choice between being unable to supply 5G compliant equipment in the UK pending trial and giving Lenovo what it wants but hasn't asked this court to order. And Lenovo makes no bones about that. The way it was put by Ms. Dagg in her fifth statement was that the court should impose a sanction on Ericsson, because, she said, Ericsson was in breach of its undertakings to Etsy. But of course, this is not an application founded on an alleged breach of undertakings to Etsy. Lenovo says as much in its skeleton argument at paragraph 23, and my learned friend acknowledged that orally this morning. But then he spent a large proportion of his submissions trying to suggest that we were in breach of our undertakings to Etsy. He said that what we were doing was in breach of contract and unlawful. Now, that was not live before the judge. There was no evidence. For example, one might expect evidence of French law because the Etsy undertakings are subject to French law. There was no evidence or argument about the scope of the Etsy undertakings in the sense that my learned friend advanced them to my lords. He tried, instead of the normal course of evidence and argument about the scope of the Etsy undertakings, to extract a proposition from some snippets of Unwired Planet and Optus and Apple. A proposition which he tried to establish, as I think, ultimately amounted to this, that where an implementer gives an undertaking to take a license, the SEP owner must not disrupt the implementer's business in the meantime pending the determination. Now, the cases simply do not say that, and yet it provided the foundation for most of my learned friend's submissions. He said we were in clear breach of our undertaking to Etsy. As I say, that was not the basis of this application. It wasn't matter which was investigated before the judge, and he can't bring it in at this stage by just pointing to a few sentences here and there in the authorities. And my lords, we say at the heart of Lenovo's case on this application lies a fundamental disconnect. On the one hand, we have the claim, which is for infringement of a UK patent, the application, which is for an interim injunction to restrain alleged infringements of that patent, and the relevant loss for American cyanamide purposes, which is that which would be caused to Lenovo by Ericsson's supplies of 5G compliant equipment in the UK and the trial. On the other hand, we have what Lenovo actually wants, which is an end to claims to injunctive relief worldwide, but it has no pleaded or cause of action or application seeking such relief. Nor, we say, is the loss of which it complains even arguably the result of the acts which it seeks to prevent by this application, namely Ericsson's supplies of 5G compliant equipment in the UK. And we say that the judge saw that disconnect clearly, and she was absolutely right to do so. So, my lords, I'm now going to turn to consider the grounds of appeal, and I'm probably going to take them in the order they appear in the grounds of appeal, just to annoy, not just to annoy my learned friend, but that's because the way I've written my note. Now, ground one is in 4 parts, but they all seek to attack the judge's finding that damages would be an adequate remedy for Lenovo. Now, ground 1.1.1.
Just before we get into the details of the grounds, can you just help me as to the position of the parties with regard to the court determination? So, Mr. Block showed us that Lenovo have undertaken to take a licence on the terms to be determined by the English courts.
Yes.
And your clients have given a sort of undertaking about respecting the decision of the EDNC. I'm not sure it quite goes so far as to an undertaking to take a licence on terms to be determined by EDNC, but that may perhaps not matter.
Well, I can show my lord that if you wish to see it.
Well,
it's helpfully set out in the particulars of claim.
Right. Okay, well, maybe that would be helpful.
Core bundle tab 11. So, my lord, sorry, I didn't give my lord the paragraph. 17.
17. Thank you.
And so what this, it explains that my lord will be aware that the way the our claim in the Eastern District of North Carolina is structured is that we ask the court to consider whether our offer is FRAND and determine that question. And if not, then to go on to determine a FRAND rate. I've paraphrased that correctly. And we can see that what we have said is that Ericsson has asked the EDNC to adjudicate whether its cellular essential patent cross-license offer to Lenovo complies with FRAND. If it's found to be FRAND, we'll provide Lenovo 30 days from the entry of judgment to enter into a license agreement consistent with that rate. If it's found not to comply with FRAND, we've requested that EDNC declare how rates should be revised to make them compliant with FRAND, and we'll give 30 days to Lenovo for...
Yeah, all right, that's helpful, thank you. So,
and just to be clear,
the broad picture, therefore, is that subject to some nuance, and I'm not saying the nuance may not be important in in other circumstances. But broadly speaking, each side has undertaken to take a licence on court-determined terms, albeit that one side is looking to the Appellants Court in this country, whereas the other side is looking to EDNC.
My lord, yes. And just to be clear, we are talking there about the EDNC.
Yes.
We're not talking about the Court of Appeal of the Federal Circuit. In other words, we undertake to offer what the EDNC says.
And what happens if the CAFC reverses?
I'm not sure what if my learned friend were to appeal the decision of the CAFC.
Are you giving any undertaking not to appeal yourself?
Well,
I wouldn't have thought so.
My lord, in effect, we've said we will offer you what the EDNC says.
Well, that's interesting. I find that surprising, but thank you. But I don't think details like that matter for present purposes, because what I'm interested in is the broad picture, not the details. What I would be grateful for, before we get into the details of the grounds of appeal, is your response to the premise of Mr. Block's argument, which is that once parties to a FRAN negotiation have committed to accept court determination, it is inconsistent with that for either party to seek injunctive relief in advance of that.
Well, my lord, firstly, just to go back to this undertaking, there is an effect, of course, on timing, because the point's being made that I will come to my lord's question, but I didn't want to forget this. The evidence is that it'll be late 2026 before the EDNC hears the case. Of course, we're committing to the first instance, as it were. Of course, by the time in the UK, by the time we've been through appeals, which is what my learned friend is only committed to taking what comes up on the final appeal, there may be very little difference in terms of timing. But anyway, I'll come back to my lord's question. My lord, we don't accept that what we've done is in any way breach of our ETSI undertaking.
No, that's not what I said.
Oh, I'm sorry. I'm sorry.
I was asking you a different question, which is not based upon the allegation that you're in breach of your ETSI undertaking. The question is whether it's not inconsistent with committing to court determination of what is frowned for either party to seek injunctive relief in the meantime.
My lord, we don't see why it is, and we don't see any principle, other than an alleged breach of the ETSI undertaking, which is what my learned friend was advancing before my lords. We don't see what principles we are alleged to be in breach of by doing what we are entitled to do in various national jurisdictions according to their law and procedure. And my lord is aware, as I think my lord's already pointed out, that the ETSI scheme assumes to start with that people will negotiate before embarking on court determinations. One hopes they might arbitrate as well, but in fact we've offered that.
Yeah.
So, my lord, I don't know if it's helpful to have a look at some of the history of how we've got to where we are. I'm quite happy to do. I was thinking of doing that at the end, but I can do it briefly now if it would help.
Well, I understand that your client's perspective on the matter is that they've tried to negotiate an agreement for 15 years and got nowhere.
Exactly.
And you say, and I understand why you say this is a classic exercise in holdout.
Yes.
And you were forced to bring infringement proceedings in order to bring the implementer, and as it happens, cross-licensor to the negotiating table. I understand all of that.
Yes.
But the question is not about the history, it's about the here and now. in circumstances where, at last, parties are doing that which arguably both should have done a long time ago, which is, given that they can't agree, asking a court to decide.
Well, yes. I mean, my lord, what happened after, as you say, about 16 years, and 2 years of them refusing even to sign to an NDA so that we could negotiate? In October 2023, we made our current offer, and that was coupled with an offer of arbitration. If my lord wants, just my lord to note, the letter making that offer and the offer of arbitration is in supplementary bundle tab 23, and at tab 24 we have the terms that were proposed, and I probably don't need to go through them and show you why that the submissions that my learned friends make about them in their skeleton are wrong. But we gave Lenovo, we told Lenovo in that letter, we offered arbitration, we gave them 30 days to take up the offer, and we told them that if that wasn't taken up, we would commence litigation. In particular, we referred to the fact we would bring proceedings in the EDNC.
Yeah, well, Mr. Tappin, I've got that, and I appreciate from your client's perspective a degree of frustration over that history.
Yeah,
that's understandable. But to rephrase the question I was asking a moment ago, your side have achieved a significant advance from where they were previously, because what you now have, which you didn't previously have, is a commitment by Lenovo to accept a court-determined license.
right.
Therefore, you know that at some point you are going to get a decision as to what is frowned.
At some point in the future.
Yeah.
Indeed. But
and that will be enforceable because you've got the undertaking.
well, my lord, we say that our acts of bringing proceedings in the EDNC, bringing proceedings in the ITC in the United States, and 2 of those proceedings have now been heard by the ITC, and we're waiting judgment, and bringing proceedings in Brazil and Colombia, were an entirely proper response to holdout. They could have avoided those consequences by negotiating a license or taking up the offer of arbitration, and they can hardly complain if we decided to enforce our rights in the face of holdout. Now, of course, they have now sought belatedly a determination of FRAND rates in this court and have given the undertaking that my lord has seen. But, my lord, that just introduces a yet further period of time during which Ericsson will not receive a penny from Lenovo from use of its portfolio.
But if your complaint is that time is going to elapse before there's a court determination, there's a simple way forward, which is to agree an interim license. And yet the position is that Lenovo are the people asking an interim license, not you. And if you think you're going to be a net recipient, I ask myself, why not? Why would a party that thinks it's going to be a net recipient not be wanting an interim license?
So, my lord, I'm trying to remember now, my lord, whether they actually agree to pay us under the interim license or just to pay it into court. I think it may be the latter, but I'd have to check that. But whatever it is, my lord, it is not bookable as revenue, because it is not a final payment. So it's not something we can account for as revenue under GAAP, as I understand it.
But at least, even if the money goes into court, that at least gives you some security.
I understand, my lord, but the answer is that we we should have been receiving revenue from Lenovo for the last 16 odd years. And they have been, we say, holding out. And what they're doing now is just taking another step in a process of holdout, which is to say, well, we've waited to the last minute. Finally, Ericsson is now taking action. We can then delay everything else by another couple of years or so while it works its way through the process.
And of course, the other point to bear in mind is that in the light of this court's decision in Digital and Lenovo, you're likely to get interest from day one at a tolerably generous rate, compounded quarterly.
Well,
so to that extent, I mean, I appreciate any commercial party will say that even that is not the same as having the money available for business use. But nevertheless, it does give you some recompense for the delay.
Some recompense, my lord. But my lord, the position is, we say, that what we have done in the circumstances, we have certainly not done, we say, anything, though obviously this has not even been investigated in these proceedings, but we say we've not done anything which is in breach of our ETSI undertakings, and we have not done anything that should lead to the court deciding to grant an injunction against us when it would not do so on ordinary American cyanamid principles. And they need to establish, using American, as they accepted before the judge, that using ordinary American cyanamid principles, they're entitled, or they should be granted in the exercise of the court's discretion, the injunctive relief that they seek. We say they can't satisfy American cyanamid for the reasons given by the judge, and that, we say, is an end to it.
Even if that's inconsistent with agreeing to court determination.
It's not inconsistent with it. It's not inconsistent with there being a court determination for the courts of Brazil and Colombia, and perhaps the United States as well, in the form of the ITC, to take the steps that are appropriate under their law and procedure when faced with the situation that pertains in that country.
You say it's a fundamental consequence of territorial enforcement patterns.
And the fact that not every court applies the same approach to questions of interim relief. They don't all apply American cyanamid, much as we might like them to. The ITC is charged with protection of the US market. All these courts have their own local laws and procedures and national commercial policy questions to consider, and they exercise their jurisdiction appropriately, and Lenovo does not suggest in this court that anything has been done wrong by any of those courts, that they have in some way exceeded their jurisdiction, or they have, they've got their own local laws and remedies and procedures. If they think that local courts have not complied with the law and procedure that applies in that jurisdiction, they've tried to avail themselves of those in Brazil and Colombia. Maybe they will in the ITC and any appeal from the ITC as well. All of that can go ahead. But for this court to say that essentially that what the courts in those local jurisdictions have done is wrong and inconsistent with the FRAN scheme, we would say
no, it's not a criticism. The argument is not a criticism of the local courts. It's a criticism of your clients for invoking those jurisdictions. That's the argument.
I understand by law, but we would say the FRAN scheme allows us to do that. If it didn't, no doubt it would have been the Brazilian court, the Colombian court, and maybe the ITC. We'll wait to see what they will say, but they would have no doubt formed the view that the Fran scheme prohibited us from doing what we're doing in those jurisdictions, but they haven't.
Can you just give me a quick update on where matters stand in the ITC?
Yes, yes, it's, my lord, core bundle tab 5, I think. Various proceedings were started in the ITC. I think you will find those lines 10 and 11 in the chronology. I think that's right. Maybe others. I'll be told if I've missed anything. Okay. And oh yes, there's one at line 33. But I think perhaps more pertinent to my lord's question is if you look at line 58. There was a hearing in July of one of those cases, decision pending. And then if you look at line 65 over the page, likewise in August.
I'm a little surprised you haven't had the decision from the hearing in July. The ITC is normally pretty quick.
Right. That one, or the July. Okay. Surprisingly, I'm told that the July judgment is expected in December and the August one is expected in November.
Oh, okay.
Which is...
Maybe that's a
I
complicated
don't know why that is.
All right, thank you.
If the inconsistency referred to was such as to amount to unconscionability, then that would potentially justify an anti-suit injunction.
If it fell within the categories, the relevant category of unconscionability, with
Yes.
the meaning that that has in those cases, then one could see...
But if it's mere inconsistency, it doesn't amount to unconscionability,
Right.
then absent some contractual obligation,
Right.
then it wouldn't justify an anti-suit injunction, not least because of principles of comity.
Indeed, my lord. And of course it's important to remember that this application has never been brought as an application for an anti-suit injunction. They forswore that before the judge. And if it had been brought as an application for an anti-suit injunction, the parties would have been focusing in their evidence on whether the requirements for an anti-suit injunction were met, and particularly issues about unconscionability. That would have been a subject of the evidence, that would have been the subject of the argument for the judge. The judge would have made findings of fact based on the evidence, and we would have been then proceeding to my lords on the basis that this was an application for an anti-suit injunction which the judge had allowed/refused, and we'd have been looking at her reasons for doing that. But that's not what's happened. And what my learned friend tries to do, in his usual eloquent way, is to slide around. You know, he brings in anti-suit injunctions, but then whenever it looks like he might be on the point of saying, well, you haven't got an anti-suit injunction, he moves back and says, oh no, it's not an anti-suit injunction, it just has some characteristics of it. But the fundamental point is, this is not an application for an anti-suit injunction. It wasn't brought on that basis. The evidence wasn't directed to that. The argument wasn't directed to that, and the judge's findings weren't directed to that. And it's wrong for my learned friend now to start saying, oh well, if this had been an application for an anti-suit injunction, it would have satisfied the test of unconscionability, because no one's addressed that.
Well, it has this in common, which is that it is an in personam injunction, which is designed to, without infringing on the jurisdiction of the foreign court, it is designed to procure that the party discontinues or in any event doesn't enforce the foreign injunction.
Yeah, that's the object. The question is, by what means is that sought to be achieved? Does Lenovo have the guts to say, we are going to make an application for anti-suit injunction. We say what you've done is unconscionable and you should be restrained from these actions in Brazil and Colombia and the ITC.
Well, the only way it's sidestepped is because they, in a sense, coincidentally, although that's an aspect of the argument, actually have a cause of action.
Right.
And which entitles them to relief of some sort eventually. And they say, well, we can have an injunction and we rely upon the unconscionability, not by way of restraining, but by way of overcoming the problem with damages otherwise being an unconscionable remedy.
Yes, but they had the choice. They could either say, we want an anti-suit injunction, let's be frank about it. We're going to say what you've done is unconscionable and you should be restrained from doing things abroad. Or they could say, we're not really sure we can do that. Tell you what we'll do, we'll bring an application for an ordinary interim injunction, and we will say that the relevant principles to apply are those of American Sign Amendment. And that's what they did. And that's what the evidence was directed to, that's what the argument was directed to, and that's what this appeal is directed to. And my lord, we say if they can't sort of have their cake and eat it. They can't say, on the one hand, we decided not to ask for an anti-suit injunction. On the other hand, if we had, we would have been entitled to one in circumstances where they haven't actually tried to ask, they haven't squarely raised that so that the parties could address it. So, my lords, I was going to go to the grounds for appeal, if I may. But,
yes, thank you.
Now, as my lords will have seen, the judge says that in a case such as this, where the parties are not competitors, the loss suffered by Lenovo for any infringements of its UK patent can be quantified as lost licensing income. And my Lord Justice Arnold took up the point with my learned friend about whether that could have been better expressed in paragraph 34, and maybe it could, but as my learned friend fairly said, it doesn't really matter. The point is that there's no dispute about the fundamental point that the loss for infringements of UK patent when the party is not in competition is lost licensing income.
Well, it has this relevance, which is that if we are supposing that there is going to be a cross license because both parties have committed to that, albeit to different cause, then the result, as I put to Mr. Block, is that there will never have been any infringement and parties will recover royalties. And that has further significance that any question of what properly goes into the analysis on a claim for negotiating damages is irrelevant. It's not a question of negotiating damages, it's a question of what royalties you get once the FRAN determination has been carried out.
Right. But whichever way one looks at it, my lord, those are all quantifiable.
Yeah.
That's really the point. It doesn't, and that's why Lenovo doesn't seek to suggest that that's the kind of head of loss it can rely on for the purposes of this application. It has to put it differently, and that's what ground 1.1 is trying to do. And Lenovo's point, as we understand it, is that unless it obtains the order sought, it might be forced to abandon its UK litigation and accept a license on what it calls supra-FRAND terms because of what it refers to as the duress caused by the injunctions in Brazil and Colombia. And the point it's making, as I understand it, is that if it does take that course, it wouldn't obtain the lost licensing income, however one wants to categorise it, that it would have obtained if it had pursued this litigation to trial. In other words, it says if I end up settling because of what's going on in Brazil and Colombia, I won't get the money I would have got had I taken this to trial. I will get something else, and we won't know what the difference is. Now, we say there are a number of problems with that submission. And the first is that, as the judge recognised, and I'll come on to deal with in more detail, there's no causal link between the acts of Ericsson, which the injunction seeks to restrain, and the alleged loss on which Lenovo seeks to rely. I'll come back to that. And the next problem with this ground is that there is, in fact, no evidence that Lenovo is, as things stand, likely to abandon its UK litigation and accept Ericsson's terms because of the injunctions in Brazil and Colombia. And we refer, my lords, to, and my learned friend took you to it, the passage in Ms. Dagg's Fifth Statement. Maybe we should just get it out again. So it's in the supplementary bundle, tab 8. And it's at paragraph 9. And she says that the parties are only litigation because Ericsson's offered rates are significantly in excess of FRAND, and obviously we dispute that, and they don't account for the significant impact of the prior license agreement between the parties. And actually, that's just wrong. The offer does account for that. But anyway, that's not what matters for present purposes. She then says, one can ask, why would Lenovo persevere with litigation once it's enjoined in two of its important markets, i.e. Brazil and Colombia? The answer is evident. It's because the rates on the table from Ericsson would cause significantly more damage than the short-term pain which is being inflicted in those jurisdictions. We say that is very clear. This is the statement from Ms. Dagg in May of this year, explaining that Lenovo's position is that it would rather put up with the short-term pain in Brazil and Colombia than agree to the rates which it now says, which my learned friend's argument is that they will be forced to take. We say this is clear evidence that they will not be taking that course. Now, my learned friend made 2 points about this evidence. The first, he said, well, if you look back at Ms. Dagg's first statement back in February, she said something different. Well, maybe she did, but that was February. This is obviously an updated and view that's been taken by Lenovo as to what course it will or will not take. And then he said, well, that only represents the position in May. Doesn't necessarily deal with the future. Well, one may ask, well, where is the evidence saying that things have changed, or that things may change, or are likely to change? It's not there. Not even after we pointed out in our skeleton argument that we were relying on this passage and saying it showed that that Lenovo would not take the course which the learned friend says it will. There was no response from Ms. Dagg saying, oh, this has all been misunderstood, or that was then and this is now, or etc. This is the way the evidence lies. And so, my lord, we say the whole premise of this argument, which is that they will be, or there's a serious risk that they will be forced to give up this litigation in this country because they'll be forced to agree to our rates. So the evidence simply does not establish that. In fact, it establishes the contrary. So that, my lord, is the first point. The second is this. Any claimant could say on an application for an interim injunction, well, damages are not an adequate remedy because while my loss is quantifiable, I might settle the case. Maybe I might be forced to settle the case because of an imbalance of arms or perceived imbalance of And then if I settle it, we'll never know what my damages would have been, and I won't get the difference. And so my losses cannot be quantified in damages, and I should have my injunction. But we say the question under American Cyanamid is whether the claimant can be adequately compensated in damages if it succeeds at trial in establishing its right to relief, not whether the claimant will be adequately compensated in damages if it settles litigation before trial. And my learned friend said I didn't have any authority for the proposition that we were making in our skeleton about this, but actually, if you just read American Cyanamid, that is what it says. I hesitate to take my lords back to it, but it's tab 1 of the first authorities bundle. At 408. Sorry, 408 of the report page, I hope page 15 of the bundle. And this is just below B, Ditlock says, governing principle is that the court should first consider whether if the plaintiff were to succeed at the trial in establishing his right to permanent injunction, he would be adequately compensated by award of damages for the loss he would have sustained. If the damages would be adequate remedy, you shouldn't grant the injunction. If, on the other hand, damages would not provide an adequate remedy for the plaintiff in the event of his succeeding at the trial. So it's all focused on what will the position be if the claimant succeeds at trial. Will damages be an adequate remedy? What the court is not considering is will damages be an adequate remedy for a claimant who settles before trial and then can say, I will get less by my settlement than I would have got if I'd taken the matter to trial. So, my lord, we say the authority is very long-standing proposition that we make. My lord, the second ground of appeal is about causation. So ground 1, 2. And as we've seen, Lenovo's argument is the fact that it is subjected to injunctions in Brazil and Colombia means that it may be forced to abandon its UK litigation and pay Ericsson royalties, which it claims are supra-framed. And it says that alleged loss, giving up its UK litigation and paying the what it calls supra-framed rates, are caused by our alleged infringements of the UK patent. The first point we make is that, as we've seen, the evidence, in fact, does not support that as a factual proposition, in the sense that the evidence is that Lenovo won't give up its UK litigation and agree to Ericsson's offer because of the injunctions in Brazil and Colombia. And so this alleged loss that's being relied on by my learned friend won't arise in any event. But we say even if it did, that loss would not be caused in any sense by Ericsson's alleged infringements of Lenovo's UK patent. It would be caused by the fact that Lenovo is subject to injunctions in Brazil and Colombia as a result of its alleged infringement of Ericsson's 5G patents. And we say the judge was right to say, and this is paragraph 44 of her judgment, that the losses which Lenovo claims arise from the injunctions in Brazil and Colombia are not losses which can on any basis be said to be caused by the alleged infringements by Ericsson of the UK patent. As she said in paragraph 40, there is a disconnect between the alleged infringement and the loss relied on by Lenovo, and she said, correctly we say, it could be illustrated by considering whether granting an interim injunction restraining Ericsson's UK supplies would have any effect on the injunctions in Brazil and Colombia. Obviously, it would not. So, as she said correctly, the alleged infringement is transparently not the cause of Lenovo's alleged loss. And what my learned friend tries to do, we can see in his skeleton, which is Core Bundle tab 3. What he seeks to do in paragraph 51, which is page 33 of the bundle, he explains why he says there is a causal link, what he calls but-for causation. And we say, what he says in paragraph 51 does not establish but-for causation, a causal link between our UK suppliers and the alleged loss relied on, which is Lenovo agreeing to Ericsson's terms, quite apart from the fact that the evidence doesn't support that, as a matter of fact. The argument, as we understand it in paragraph 51, is this: if Ericsson is forced to choose between stopping UK supplies and taking away, as it were, what would be the cause of Lenovo's loss, either injunctions in Brazil and Colombia, then Ericsson will choose the latter. And we say that's just sleight of hand. It seeks to disguise the fact that the cause of Lenovo's loss, if it happened, which on the evidence it won't, would be the injunctions in Brazil and Colombia. And there's no causal link between Ericsson's UK supplies and the injunctions in Brazil and Colombia, or the loss on which Lenovo relies. The truth is that Ericsson's acts of supply in the UK are just something being used by Lenovo as a basis on which to ask the court to create a situation in which Ericsson is forced to choose whether to take away the injunctions. They're asking the court to create a connection which at the moment does not exist. So, my lord, we say the judge was completely right on the issue of causation. There is no causal link between the acts which it is sought to enjoin by this order and the loss which is relied on by Lenovo. Now, my learned friend, I think, in an effort to suggest that the point on causation was arguable, he took you to the case of Smith and Nephew briefly, and maybe I should just explain the context of that case and the one that it refers to, which is Coflexive and Stolt. Maybe we should get it out. The authorities bundle Convatec is in bundle 2 of my Lord's Authority, tab 13, I think. I'll then throw it to it. And this, of course, refers to the preceding Stolt case. And I think probably my Lord Justice Arnold is familiar with that one. But just stepping back, what both these cases, Stolt and Smith and Nephew, about are ones in which there was no dispute that there was but-for causation. And the question was whether the claim would succeed or fail because of some additional requirement to but-for causation. So in Coflexive and Stolt, Coflexive and Stolt was a case where there was an inquiry as to damages following an infringement, an established infringement, which was about laying pipes of a particular type using a particular kind of equipment in the North Sea, subsea pipes. And the question was whether it was enough that the defendants had obtained the contracts by offering and using a method which in fact infringed, or whether it was necessary to plead and prove that the contracts had been obtained because the defendants offered and used the particular method. So there was no dispute that there was but-for causation. The question was whether there was some additional requirement, and that was the matter which was held needed to go to trial. I think
What you're saying, Mr. Tappan, is perfectly accurate. But as I pointed out to Mr. Block, this is history now. Because what happened in both of those cases was the court said, well, this should go to trial.
Yes.
And once the facts have been found, then we can debate the law.
Yes.
But since then, we have had a case in which the facts have been found, as it happens by Mrs. Justice Bacon, and the law has been settled by this court on appeal from her. That's Anand Kasai.
Right.
So we know what the law is now.
Right. Okay.
So why are we excavating into ancient history?
Okay, my lord. I will. The simple point I was going to make is that my learned friend seemed to be. Maybe I misunderstood him. I thought he was saying on the basis of Smith and Nephew and Convatec that issues of causation require a determination of the facts, and you therefore it's all arguable, and you can't shut me out on the basis that there's no arguable causation. I thought that was the point, but relying on it. But maybe I misunderstood. But
what if that was the point? At the moment, it seems to me to be misconceived, because the question which was being debated about that stage, as you rightly said, was what more was required beyond but for, because it had already been said in Gerber and Lectra that but for was never sufficient. More was required, but there was a degree of uncertainty as to what more.
Right.
And the answer that's been given is what you need in addition is approximate causation.
Right.
To put it shortly.
Yes. We say this case is one in which the judge has held there was on no basis was there any causal link. And so it's not a case in which it can be said by my learned friend, indeed it isn't said by my learned friend, that any further facts need to be found before one can come to a conclusion on causation. He hasn't identified any areas of factual inquiry which mean that his claim is arguable, or may be arguable, and needs to be determined at a trial. The judge has said on no basis there is a causal link. We say she was absolutely right. There is no but-for causation in this case. And that was really the point I was going to come to. So, my lord, that is the ground 1-2. Ground 1-3 is, they say, well, the judge didn't go on to consider foreseeability and whether there was exclusion from recovery by policy. We say, well, she didn't need to, because she said it failed the basic factual causation element, and that's all there is to it. Ground 1-4, this is the point about patents. They say that patents, even sets, have, as they put it, defensive value as a deterrent against others operating in the same area. And the suggestion, as I understand it, is that that value is diminished if the court doesn't grant an interim injunction. Now, my lord, we do say this was a point not run below, and my learned friend, and it wasn't run below as a head of loss, which is how it's now put. All my learned friend could point to was the fact that there's a mention in his skeleton below of the fact that this was as he put it, a defensive, they were asserting this patent defensively. He couldn't point to anything where it was argued as a head of loss. So it wasn't run below, and it's unfair to criticise the judge for not having addressed it. But we say it is in any event a really bad point. And of course, any rights owner could say on an application for an interim injunction, look, if you don't grant me an interim injunction, my right will be worth less. And the reason why analytically it's wrong is this. Let's assume that, as they say, the value of a right such as a patent is affected by what they call the willingness of the court to grant relief in appropriate circumstances. Now, on that basis, a UK patent carries with it the value which derives from the fact that a UK court will be willing to grant interim relief in circumstances which satisfy American sign amid, and not if the circumstances do not satisfy American sign amid. That's what they would call the associated value. But that value is entirely unaffected if the court decides to refuse interim relief in circumstances which do not satisfy American sign amid. Because that's exactly what you'd expect, and that's what's built into the value. And that's why it's an entirely circular and bootstraps argument. Because there is no diminution in value beyond what one would expect. You're getting exactly what you'd expect if the court says, you don't pass American sign amid, I'm not granting an injunction. My lord, that's the end, I think, then of ground 1. Ground 2 is about the balance of convenience. And we say, obviously, like the judge, we don't get to this point because damages are an adequate remedy for Lenovo. Now, this is addressed by Moylan and friend in their skeleton from, I think, paragraph 57. And they start with the concession that the loss that Ericsson would suffer if it ceased to sell 5G compliant goods in the UK would not be adequately compensated in damages. And that is then recorded by the judge. I think Moylan and friend showed you this in paragraph 45 of the judgment. And, my lord, that concession, while inevitable, doesn't really do justice to the scale and severity of the loss that Ericsson and third parties would suffer. That was addressed in our evidence for the application, in particular the statement of Ms. Dooley and the reports of Professor Valdar. I wasn't going to take my lords to it unless you want, but it's summarised in our skeleton before the judge, which is supplemental tab 3. And the damage is summarised at paragraphs 99 to 102. We go on in that skeleton to explain why damages wouldn't be an adequate remedy at 103 to 107, and why the balance of convenience lies against the grant of an injunction at 108 to 117. As I say, unless you want, I wasn't going to take you through that, but my lord, the damage to Ericsson and third parties such as mobile network operators would be very substantial and irreparable. Now, if we then go back to Lenovo's skeleton, the point that they make is that they say there's no serious likelihood of the loss to Ericsson arising because the harm to Ericsson and third parties in the injunction is so great that Ericsson would be bound to opt for one of Lenovo's preferred alternatives to avoid that harm. And as they say, as we see in paragraph 61 of their skeleton, they say the damage that will be caused is loss of leverage, and that provides the starting point for their submission on balance of convenience, which you see in paragraph 64. And this is where we say, again, the disconnect identified by the judge arises. Because the harm to Ericsson is not loss of leverage, but the harm that would be caused by preventing it supplying the 5G equipment in the UK pending trial. That's the order which they seek. They seek an order preventing us from doing that. And it's the loss caused by that injunction that the court needs to consider when addressing the balance of convenience. And it's wrong in principle, we say, to consider instead the loss that would be caused to Ericsson by doing something to avoid that injunction. And we say it's also wrong in principle to make an order which would cause Ericsson very substantial and irreparable harm in order to force it to do something which Lenovo has not asked the court to order. And so, my lord, we say if you get to the point of considering the balance of convenience, the question is whether that lies in favour of preventing Ericsson from supplying 5G compliant equipment in the UK pending trial. question is whether the irreparable harm to Ericsson of such an injunction outweighs the irreparable harm to Lenovo of refusing that injunction, and we say plainly it does. The irreparable harm to Ericsson and third parties would be very substantial, and there is no irreparable harm to Lenovo of refusing it. My Lord, ground 3, this is the allegation that the judge wrongly treated her discretion as being fettered. And if my lords go to my learned friend's skeleton, so this is core bundle tab 3, the argument, as we understand it, is, well, what's said in 68 is that they refer to 29 and 30 of the judgment, and they say, the judge held that an interim injunction must always be founded on a risk of harm to the claimant that is legally caused by the infringement of the claimant's right of which vindication is sought, and therefore recoverable at common law. And my lord, that's simply not what the judge said. She expressly said that an interim injunction can be granted to prevent a loss which may not be recoverable in damages. So they're just
That's
wrong.
true, but she went on to say that the foundation injunction must always be a risk of harm to the claimant caused by the infringement of the claimant's right of which vindication is sought in the underlying claim, relying on what was said in Brave Vulcan. Now,
Right.
the law's moved on since Brave Vulcan, as I was exploring with
Yes.
Mr. Block. So, taking the website blocking injunctions as an example, as I said earlier,
But
lots of injunctions have been granted against internet service providers who it's accepted have committed no wrong whatsoever.
my lord, if you're seeking what one might call an ordinary interim injunction, to which the principles in American Sign apply, then we say the judge is completely right about this, and that's entirely inconsistent with what Lord Diplock was saying, and I've been showing my lord earlier. Of course, there are situations in which equity has devised other forms of injunction, and one can name, amongst other things, the anti-suit injunction, the website blocking injunction. One might wish to categorise put in that sort of category injunctions against persons unknown, for example, as in Wolverhampton. Those are different kinds of injunction which equity has crafted to meet those particular kinds of circumstances. But here we're not faced with that. We are faced with what I call, for want of a better term, an ordinary interim injunction, to which American Sign applies, as the Moylan and friend have accepted before the judge and has presented his case as being based on the principles of American Sign. And, my lord, it may be helpful.
Well, Mr. Block's best analogy was with freezing orders.
Freezing orders, again.
Where the injunction is not based on the underlying cause of action.
Of course.
It's to preserve, as he put it, the court's jurisdiction, or the effectiveness of the court's jurisdiction might be a better way of putting it.
Yes.
Pending determination of the claim.
Yes, and that's exactly. It's to ensure that if a money judgment is made, then there are the means available to satisfy that money judgment. My lord, but that and different principles apply to moreover injunctions, to anti-suit injunctions, to website blocking injunctions, to those that apply to ordinary interim injunctions, where as my learned friend agrees, the American Sign principles apply. And my lord, I don't know if my lord's probably familiar with this. I was going to ask my lords to look at the summary of the position by Mr. Justice Mellor in Crypto Open Patent Alliance and Right. May be helpful. Just it sort of brings together broad idea, Wolverhampton and so forth. It's in my lord's fourth bundle of authorities at tab 28. And it's at page 1457 of the bundle, paragraph 27. And although obviously it's a first instance judge trying to summarise the Supreme Court, it's one put forward by Moylan and friends, so I don't suppose too much criticism can be made going to it. I would just draw my Lord's attention to subparagraphs 3 and 4.
Sorry, could you give me the paragraph?
I'm sorry, paragraph 27 on.
Thank you.
So he's referring to Wolverhampton and Broad Idea. And obviously the whole of this is relevant, but I was going to highlight 3 and 4. Let me just ask my lords to look at that. And the point really arising from this is there are different categories, and new categories may emerge, but each category has to be applied in accordance with the principles that have been developed for that category. And in this case, it's American cyanamide. Of course, different forms of injunction may need to be created in the future, but in this case, there is no lacuna to be filled. The court has at its disposal, with established principles for the exercise of discretion, both ordinary interim injunctions to protect a right, and of course there is the availability of an anti-suit injunction, though obviously one has not been sought in this case. There's no need for equity to innovate in this case, where you have an ordinary interim injunction, which is what's been sought and to which we have established principles, and we have available anti-suit injunctions which Moylan and Friend has not sought. And there's a suggestion in Moylan and Friend's, sorry, probably put away that authorities bundle. There's a suggestion in Moylan and Friend's skeleton, and we really see this in 71, the skeleton, page 39 of the bundle. What he brings out is this idea that somehow you should grant an injunction because there is what he calls sufficient connection between the loss and the infringement. You see that in 71, he says there is sufficient connection between the loss and the infringement, and in 74, he says you could grant an interim injunction to prevent loss which is sufficiently connected to the infringement. Now, this appears to be just another attempt to sidestep the fact that the alleged loss isn't caused by the alleged infringement. It seems, as we can see in 71, to be based on some alleged breach of our ETSI undertakings. But as I've already discussed, my lord, as they themselves say, this application is founded on an alleged breach of Ericsson's ETSI undertaking. They end up, I think, really just saying in 73 that the sufficient connection arises because of the, quotes, wider commercial position between the parties. And the problem, my lord, is that there's nowhere here is there any proper application, proper articulation of any principle which Lenovo says should guide the court. Even if it were open to suggest that there should be a departure from the American cyanamide principles, and we say it's not open to it because that's not the basis on which made this application. But even if it were open to Lenovo to say, oh, there's some new principle that should be applied by the court to which would justify an injunction in these circumstances, what is that principle? And Moylan and friend had a go at saying what he said the principle was. It was actually quite a long series of not very connected statements, but what he said, and there were 5 or maybe 6 points, I lost track, were either points which arise from American Cyanamid about the adequacy of damages, or they were points that would arise if he'd applied for an anti-suit injunction, which he hasn't, or they were based on an alleged breach of Etsy undertakings, which is, as he says in his skeleton, not the foundation for this application. So it wasn't really any sort of principle at all. It was just a collection of things that he'd like to be able to say in this case. And we say there is no need for equity to innovate, to come up with some new form of injunction. In these circumstances, the standard forms of injunction adequately cover the position. Either he can ask for an ordinary interim injunction, which he's asked for, apply American Cyanamid, or he can ask for an anti-suit injunction, which he hasn't asked for, and then we have to apply the principles that we would have to if that was the apply the principles that arise on such applications. So, my lord, we say there is no basis for creating some new form of relief, which seems to be what he might be saying in ground 3. And ground 4, the way ground 4 is advanced in the grounds of appeal, as they say, the judge erred in law in holding that the relief sought was by way of an anti-suit injunction. Well, she didn't. It's just wrong. She was well aware that Lenovo was not seeking an anti-suit injunction. One sees that from paragraph 43 of her judgment. And the point she was making in paragraph 9 of her judgment was that while it wasn't seeking an anti-suit injunction, it was seeking to achieve what was in effect anti-suit relief by the back door without having tried to satisfy the requirements for an anti-suit injunction. And so they're just wrong to say, as they do in their skeleton, that the judge held that issues of comity, I'm quoting paragraph 1 of their skeleton, they said the judge held that issues of comity precluded the grant of the order unless the conditions for anti-suit relief were met. That's just not what the judge said, because she didn't have to address whether the conditions for anti-suit relief were met because there was no application for an anti-suit injunction. And obviously we hadn't addressed that issue either for the same reason. So, my lords, we say there's absolutely nothing in ground 4, just like all the other grounds of appeal. And so, my lords, we say simply the judge was right, the reason she gave, and the appeal should be dismissed, unless, I'm sure, those are our submissions.
Thank you very much. Yes, Mr. Blower.
I will begin, if I may, by addressing the terms of the order and recording that if the court is otherwise with us, we acknowledge that an appropriate adjustment needs to be made to the language of the order in order to put it into the appropriate form for an interim rather than a permanent order. The second point that I would raise concerns a matter that my Lord Justice Arnold raised between bench and bar with me concerning Ericsson's position as regards the court determination by this court of a brand license. The presumption was that, and recall it, that Ericsson would offer such a license or take such a license, so far as the cross license relates to the Lenovo portfolio and in particular EP649. As I understand it from my learned friend's submissions, that is not in fact Ericsson's position. But the fact that Ericsson, it would appear, will not accept the terms of a court-determined cross-license in this country does not in any way impact on the adequacy of the undertakings that are offered by, the fact that Ericsson will not accept that does not in any way impact on the adequacy of the undertakings which are offered by Lenovo. The position appears to be that whilst Lenovo is committed to accept those terms, even if there is a court determination in this country as to what the terms should be, Ericsson will do or reserves the right to avoid taking them. And therefore, when considering whether to grant an injunction today, one should not assume that even if we get to a trial, Ericsson will accept the terms that are then on offer. It may not, for the reasons my Lord Justice Arnold discussed with my learned friend, ultimately matter how one analyses it, but we could well be in a position where we are seeking damages because the royalties that would flow from a license presuppose that there will be one. I then turn to the submissions my learned friend made in the order in which he made them. He says that this is an application that was made before the judge of first instance on the basis of American cyanamide principles, and therefore the wider considerations that we have sought to advance should not be open to us. First of all, my lords will recall from the judgment itself, the judge stressed that the view of American cyanamide that we were arguing before her was not one where the rules are written in stone, but one as indicated in the cases that we cited to her, including in particular the Moylan case and the judgment of Lord Justice Mance in that case. So the suggestion that we were inviting her to deal with the matter as if it was, as it were, an entirely orthodox, required an entirely orthodox application of the American cyanamide principles, as Lord Diplock himself might or might not at the time have been taken to consider them, is not in any way a fair one. In any event, it's not simply a question of whether one's being fair to the judge at first instance. The arguments that we've advanced and for which we've had permission to advance on this appeal, are set out in our grounds of appeal, are clear. My learned friends have had notice of them. And the only point that he has raised in relation to prejudice relates to the possibility of serving French law, or evidences to French law, in relation to the matters on which we rely in relation to Etsy. My learned friend is somewhat harsh in saying that we didn't run a case in relation to Etsy at first instance. It is, we would submit clear from the judgment, and if necessary we can go to the transcript as well as the skeleton to make it, to show, one, that a considerable amount of time and space was occupied by consideration of Etsy obligations, and that it was always one of the two pillars of our case as to unconscionability that the conduct of Ericsson was contrary to its undertaking and the proper operation of the ETSI regime. Lord, it is said that we need, under the American assignment principles, to show that damages would not be an adequate remedy. And in the case, however one categorizes it, one of the first things one's going to look for is the nature of the loss and what compensation for the loss the court can provide if one gets to trial. So the precise classification of that exercise may not advance matters enormously. Where it is important to be clear, we would submit, is in distinguishing two losses here. One, the loss that we are currently suffering as a result of the damage to our business in Brazil and Colombia. And two, the loss of negotiating position, which we suffer as a result of the loss of a level playing field. If Ericsson were not pursuing the enforcement of the injunctions which it is pursuing in Brazil and Colombia, and the exclusion orders that it is seeking in the ITC, there would be a level playing field, and the negotiation between the parties would be one which could go on in parallel to any court proceedings and might result in an agreement, and one would expect an agreement in line with the sort of determination that the court might make as to the terms of a FRAND license. But we are not in that position. The negotiation that Ericsson wishes to have today is one where the parties' positions are asymmetric. They have all the advantage.
When you distinguish between the two losses in that way, it invites this question. Insofar as you are distinguishing the second form of loss from the first, why is there not a perfectly level playing field? Because in this case, both sides hold portfolios of SEPs, so both are in a position to take enforcement action against the other in the national courts. So you have a level playing field. They've injuncted you in Brazil and Colombia. You can go and injunct them in, let us say, Germany and Japan.
My Lord, there are two answers to that. One, of course, that in a sense it is correct, but it leads to a general madness. Secondly, if and in so far as it might be correct, it would be dependent on a balance of portfolios. And thirdly, it assumes that the strength of the parties, their ability to injure one another in these circumstances, is an appropriate thing to take into account in setting the playing field. And of course, one of the submissions that we make is that it is not that a madness in which the parties seek to destroy one another pending the determination of the court, that is not the context in which any negotiations should take place. But my Lord is perfectly correct, of course, that one response, if we are being disrupted, is to seek to disrupt the other side. Now, if the portfolios are entirely balanced and the ability to enforce them were entirely balanced, then the impact of the particular actions which have been taken by Ericsson could themselves be balanced. But it doesn't follow that simply because one has a portfolio which could be deployed to a greater extent in that way, that the orders that have actually been obtained and are being enforced do not unbalance the negotiating position. So we would not accept that merely our ability to injure Lenovo as a matter of theory and a matter of principle must create a balanced situation. But what we do say is that the effect of the order would be to, as my learned friend says, put Ericsson to a choice. It can either comply with the order by withdrawing from the United Kingdom, or it can comply with the order by complying with the proviso. But that is entirely in keeping with the nature of the right that they are accused of infringing. Because the infringement involves either the way to avoid the infringement is either to withdraw or to obtain permission. And of course, the value, as we have said, of the patent lies not simply in an ability to exclude, but in an ability to use the possibility of exclusion to obtain a fair and appropriate royalty for granting permission. And that is what underlies the whole notion of the negotiation of user damages, in relation to which I've already addressed, my lords, as to the appropriateness of taking into account the position of the individual parties, the actual parties, when considering what the outcome of that negotiation would be. One's not simply considering two parties in the abstract, one's considering the parties with all their negotiating and bargaining positions, and therefore in this case, considering, so far as Lenovo is concerned, a party which is being asked to permit user in this country in circumstances where its own business is being disrupted in others. I put it in that way because those are the facts of this case. But when one's thinking about it in terms of the assessment of user damages, the difference between the territories is not the pertinent point. The pertinent point is that the party that needs the license, in this case Ericsson, is simultaneously seeking to, or has the means to, by way of orders or otherwise, disrupt the business of the person from whom it is seeking that license. And in that context, we say, it is at least seriously arguable that the party in Lenovo's position will say, yes, I'm prepared to license you, but one has to have regard to the fact that you are doing as against me the very thing that you are asking me to abstain from doing as regards yourself. And there will be a price to that. Now, it may be said against me, well, if that's right, ultimately, one will be able to recover that loss. because if that is going to sound in damages, it will be quantifiable. And that's what the learned friend, I think, says in answer. But it depends critically on a very, very narrow view of how the American cyanamide principles are to be applied. You will recall that he took, well, it took you, my lords, to the words of Lord Diplock and pointed out that the way in which the American cyanamide principles are set out presupposes that there will be a trial at which the question of damages will be determined. And he is, of course, completely right about that. But we would submit he is completely wrong in interpreting those rules in a way which assumes that the particular fact pattern that is posed in this case was in Lord Diplock's mind. He is doing the very thing that you should not do. He is reading those words as a statute, and indeed reading them as a statute without regard to context or purpose. The particular problem that arises in this case, if we are right on the facts, and I'll come back and say something briefly in relation to what my learned friend has said on the facts in a moment, but the particular problem that arises in this case is that the threat is that there will be no trial. Now, my learned friend says, well, anybody can say that damages won't be an adequate remedy because I may settle before the trial. And it is no part of our case that this is an argument that should be open to anybody. What we submit is that it is an argument which is properly advanced where the mischief which one is seeking to stop is itself directed to the frustration of the judicial process. This is a case in which our complaint is they are trying to prevent us from getting to a court decision. And the suggestion that the language of American cyanamide determines the answer to that against us is, we say, wholly misguided. One only has to step back, we say, and consider the broad, the obvious injustice, or as it were, catch-22 of my learned friend's submission, that if we have a cause of action which entitles us to complain about conduct which will prevent us from getting to trial, we can nonetheless never get an injunction, because if we got to trial, then we might get some damages for it. But of course, that is the catch-22. And friend says that in relation to the case we advance in relation to Etsy and the Frand regime, we are seeking to put forward a position in relation to which it would be necessary to have French evidence, or evidence of French law. And therefore, we should not be permitted to do so. We say that that is quite wrong. What we are doing is simply drawing together the judgments that have already been delivered by this court in relation to the way in which the parties who have given Etsy undertakings should conduct themselves. Now, in theory, and I don't think he was going this far, one might say, well, French law is a question of fact, and we're dealing here with an undertaking which is governed by French law, so there should be, as it were, no precedent at all in relation to these matters, and they could all be re-argued in later cases, regardless of what has been said by the Supreme Court or the Court of Appeal. That's simply not the way in which, in relation to matters of this kind, the English court proceeds. It's not the hypothesis on which one sees the matter dealt with either in unwide planners in the Supreme Court or here.
That, because if the French court said that we got it wrong, we would change. However, in fact, that's not been the experience so far. On the contrary, subsequent French court decisions have been consistent with unwide planners.
My Lord, yes. And in the event that it was suggested that each case should be dealt with on fresh evidence, one would get a very frosty reception. So, as a practical matter, what the English court has laid down, both in the Supreme Court and in the Court of Appeal, subject to it turning out as a result of a judgment in the French courts of precedential value being said to be wrong, is treated as law. And what we have is decisions both in the unwind planet case and in the Optus and Apple case, and, as my Lord Justice Arnold pointed out in the most recent decision in Interdigital and Lenovo, which, if it will assist, we will hand up to include in the bundles, which set a regime requiring parties to act in a certain way. So we say it's not necessary for us to adduce evidence. All we are seeking to do is to draw together what is said in those cases, and that when they are properly drawn together, one can see that there is a obligation on the part of those who have given a ETSI undertaking to conduct themselves fairly and reasonably, which we submit extends where the parties have been unable to agree and there is to be a court determination to fairly and reasonably permitting the proceedings to continue and as such a determination to be reached. One might not have thought that should be particularly controversial, but apparently it is, or at least my own friend, he hesitates to put it quite as starkly as perhaps he needs to. What he does is he turns to the history of the matter and he says, well, there has been lots of behaviour which we consider bad on the part of the other party, so we can be forgiven for taking the measures that we have taken. But the point that he has failed to address is the point that is made by my Lord Justice Arnold in the Optus and Apple case, that once the undertakings are offered by the licensee, or potential licensee by the implementer, they should be treated as a willing licensee. We have given the undertakings. Whatever the appropriateness of seeking injunctive relief and the disruption of Lenovo's business might have been up to that point, at that point, we are to be treated as a willing licensee and not deprived of the benefit of the determination of the terms of the license which we have undertaken to take. Now, the next point I should probably deal with is the suggestion that what we are seeking here is holding Ericsson, as it were, interoram. I think it's one of the phrases that is picked up from the judgment, interoram and hostage. I'll deal separately with backdoor. Not quite sure what's wrong with backdoors, but I'll deal with that as a separate issue. It may be that, as a matter of law, my lords will be against us, and we will be unable to obtain the order that we have sought. But there is, whether we can get it or whether we can't, characterizing it as interorem, or holding them hostage, as we say, quite inappropriate. What does the order do? The order requires them to cease infringing our patents unless they're willing to comply with the proviso. That's the form of and substance of the order, regardless of the cause of action underlying it. What is the order, or what are the orders that they have obtained in Bolivia and Colombia? Sorry, Brazil and Colombia. Their orders, which require Lenovo to cease practicing their patents in those countries, there's one difference. Ours has the proviso, theirs have no equivalent provisos. We are saying you should do this or accept a court determination or at least stop attacking us. They're simply saying you must cease your business. They cannot sensibly argue that the order, if you put to one side the underlying cause of action, is interorem, circumstances where they regard their own orders as entirely legitimate. Can't say that we are holding them to hostage in circumstances where they are doing the very same thing, save for the fact that they're not giving us the out that we are offering them. So one can put to one side all this talk of interorem and hostage. What underlies this is an entitlement, as Ericsson sees it, to rely on what Ericsson says is the difference between the UK practice, English practice, and the practice elsewhere. They say it's perfectly reasonable for them to obtain such relief as they can in other jurisdictions, and it is also perfectly reasonable that the law in this country does not permit, does not lead to the granting of equivalent relief in relation to UK patents. Well, we would observe the following points about that. First of all, it does have the consequence, may or may not matter, that a UK patent will, as a practical matter, be a much weaker thing than a foreign patent, at least in those countries which are more willing to be muscular in relation to their patents will have patents which will be of greater value. That may or may not matter, a matter of principle, but it is a fact. The second point is that if they have sought to advance their case in Brazil and Colombia as they have, whilst they may say, well, it was purely opportunistic, they've also said that it was legitimate. So it's hard to say that the nature of the relief that they've obtained there and the circumstances in which they have obtained it is something which they could properly criticize the English court for granting in the event that, on reflection, this court thinks that is the proper way in which this court should proceed. But in any event, it's not simply a question of focusing on the effect of the injunction or the willingness of the English court to grant injunctions on the value of the English patents here. What we're actually talking about is the monopoly right that Lenovo enjoys, or should enjoy, in respect of the period pending a trial of its infringing claim, if there ever is one. What will have been lost is the opportunity to have insisted that if Ericsson wishes to continue to operate in this country, it operates with our. In other words, there is
But if you're relying upon maintenance of monopoly, neither side have done that at any stage in these proceedings, because maintenance of monopoly requires injunctive proceedings to be launched basically as soon as you become aware of an infringement. And in fact, what's happened in this case is both sides, for whatever reason, until 2023, have tolerated each other infringing their respective portfolios. Neither side has attempted to enforce their monopoly.
Lord, it is perfectly true, as I understand it, that neither side has attempted to enforce their monopoly for many, many years.
And there is, in fact, a perfectly rational explanation for that. And that's because both sides know that they can't enforce their monopoly, because both sides are subject to their undertakings to license to all comers on fair, reasonable and non-discriminatory terms. So these cases are not about enforcement of monopolies. They're about getting the money to which you're entitled by virtue of the Fround rate.
My Lord, it rather depends what my Lord means by these cases. Ultimately, if one's focusing on the nature of the dispute, of course, we agree, it's about money. There will ultimately be some kind of cross-license or licenses. So if one's talking about the dispute, yes, ultimately, it's about money. If one's talking about the nature of the cases in the sense of the underlying causes of action, then one has to be a little bit more careful about which cases one's referring to, because in the classic form of a Fround case, the foundation is a claim of patent infringement, and the question of the determination of the terms of a Fround license arises in the context of the fashioning of a Fround proviso to the injunction that the court will order in the event that the infringer is unwilling to undertake to enter that license. But, my Lord, can I come back and deal with the, as I understand it, the point underlying my Lord's observations in relation to the non-enforcement of monopolies. It is perfectly true that there was a period, a substantial period, during which neither side was seeking to enforce their patent rights. And it is also true that one might see that as something which should be applauded in a Fround context. But what we're concerned with here is not the period going back 10 or 15 years. We're focusing in particular, if in so far as it's necessary to look at this matter narrowly and ask whether damages will be an adequate remedy for the infringement between now and trial, at the period between now and trial. That's the period which, in relation to which the question arises, well, will damages be an adequate remedy? One can't do anything in relation to the past, and of course, in relation to the position post-trial, that will be a separate matter. So we're focusing on the interim period, and if and insofar as it's appropriate to have regard to the to damages as user damages, we're asking what it is that might reasonably be required by Lenovo by way of user damages in respect of that period, leaving aside the fact we probably won't get there or may not get there, but assuming for the moment that we might, in respect of that period, in circumstances in which Ericsson is injuncting us in other jurisdictions and seeking to ramp up the pressure in a way which will mean we never get to trial. But we say that in those circumstances, in that negotiating context, we would be entitled, or it's at least seriously arguable we would be entitled, to have regard to our bargaining position and say, no, if you want the right to operate here with our permission whilst not permitting us to operate anywhere else, and therefore put yourself in a position to negotiate a global license where we are under pressure to agree it and you're under none, that is going to require you to pay us an appropriate sum. In the commercial world, it would be entirely clear that no one would give up their own negotiating leverage to a party which was applying the very same kind of negotiating leverage against them without exacting a price which reflected the loss of bargaining position that they would lose thereby. And yet that is what we are supposed, in this case, to do. And it is said that unless we do that, we are somehow holding them hostage. Can I then just deal with the back door point? And the back door point is, I think, tied up with a point about the categorization of different forms of injunction. There are a number of grounds on which one may seek injunctive relief. And it is quite often the case that one will plead more than one such ground in the same claim, the same proceedings, and that one will rely on more than one such ground to obtain the same or a very similar order. Claim in breach of confidence, in contract, or a claim in breach of confidence in equity or common law may be essentially the same. Claims in negligence, in contract, and in tort. In other cases, it may well be that one will have claims in trespass or nuisance or whatever it is, which will, as a matter of substance, be overlapping in the kind of relief that you may be entitled to, assuming them to be well-founded. There is no principled reason why we should be deprived of the relief we're seeking in this case if we would otherwise be entitled to it, simply because there is an alternative cause of action which we might have sought. I say alternative cause of action, but in fact I may have somewhat misspoke. There is, of course, a circularity. There are two senses in which one talks about causes of action. There's a sense in which one's talking about substantive claims in contract or under particular heads of tort. And in that sense, there is no cause of action involved in, for example, a freezing order or an order for an anti-suit, Although, of course, in another sense, where a cause of action is a set of facts which gives rise to a basis on which the court will grant a remedy, even in those cases there is a cause of action, and it is, of course, therefore circular, because where there is a willingness to grant a remedy, one will have found a cause of action. In the case of the classic anti-suit, there is no cause of action in the first sense. One is relying entirely on the fact that the conduct which is being sought to, one is seeking to restrain, is unconscionable. Or conduct of a kind, if unconscionable, as Lord Gough, I think, has indicated, may itself be too narrow, conduct of a kind at which the court will, in justice, restrain. In this case, as I think was observed by my Lord Justice Phillips, we do have a cause of action in the conventional sense, or the more limited sense. We have a cause of action for patent infringement. But the difference between this case, or a difference between this case and the classic anti-suit case, is that we do have in this case something missing from those cases. We have a freestanding cause of action, entitling us, at least at trial, and therefore potentially on an interim basis, to injunctive relief. And that's the context in which the unconscionability of Ericsson's conduct is to be judged in this case. We do not need to satisfy all the conditions of an anti-suit injunction because we have a separate cause of action. But insofar as it may be relevant, and we submit it is, to have regard to considerations of unconscionability, yes, of course, the things to which you're having regard will overlap very much with the considerations that one would take into account if this was being proceeded and pursued as a anti-suit application.
Just to be clear, the classic line of cases on anti-suits, Angelic Grace, Donahue,
or contraction,
and AES are all, there is a cause of action.
In some, yes, but in others, what is being prevented, for example, is the pursuit of proceedings in a third jurisdiction, or whatever it may be, normally Texas for some reason. And those cases aren't based on contract. Those cases are based on what used to be characterized as oppressive and vexatious conduct, and then more generally as unconscionable, and then yet more generally, as I believe by Lord Gough of Chiefley, as something wider, as the matter was then dealt with in the Channel Tunnel case. But, Lord, yes, I concede that there are also, and maybe the early ones in particular, were straightforward contract cases. So, my Lord, we say we have a cause of action. It's one that gives rise to at least arguably substantial and recoverable damages in the technical sense, but damages which we may well not recover by virtue of the nature of the mischief which we face. There are two, I think, further points which I would endeavour to deal with briefly in the remaining time. First, in relation to the question of whether or not there's any serious likelihood that Ericsson's strategy will succeed. Then the friend reiterated what was set out in his skeleton argument in relation to that, but failed to address the points that we make in relation to it, not only in relation to a fair reading of paragraph 9 of Ms. Stagg's fifth witness statement, but also, and perhaps most remarkably, why they would be doing this if there was absolutely no commercial advantage to them from doing it. If there is no serious prospect of Lenovo accepting the terms that Ericsson is offering pending a court determination, which appears to be what Ericsson is saying the court should accept, it can only be acting out of malice.
Their objective is to get you to agree to what the court would ultimately determine, but to get you to agree it quickly, more quickly.
Well, that's
what's illegitimate about that?
Two things, my lord. First of all, I think possibly more than two. Firstly, it's not the way that they put their case. They talked about getting us to agree to a license. But leave that to one side. Secondly, where undertakings have been given, as they have, we say, as a matter of the law as it stands in this country, we are to be treated as a willing licensee. And whilst it may be entirely legitimate for them to seek to take such steps as are open to them, both in this country and elsewhere, to argue about matters of jurisdiction and the like, it is not legitimate for them to put that kind of pressure on us, given that we are be treated as willing licensees. I should also have noted in that regard that whilst the learned friend said something about the timing of a trial in the EDNC, he did not challenge the points we make by reference to the judgment of Justice Richards as regards what may or may not be decided in the EDNC, and the fact that there is on the evidence a real possibility that the EDNC will not decide the terms of a brand license at all, but what it will decide if it gets there is simply a question of whether or not Ericsson has complied with its undertaking, which, depending on how that matter is argued and what view the court takes, would simply be focusing on the negotiating process, during which, at least on some views of the matter, may be a process in which one can comply with the one's undertaking by making an offer which is supra-frand, as long as that offer is not so obviously supra-frand as to render you an unwilling license. So those arguments may perfectly legitimately, the arguments to which my Lord Justice Arnold refers, may perfectly legitimately be raised in due course in proceedings, but we say, and on the authorities to which we've relied, they are to be raised in proceedings rather than have those proceedings short-circuited or attempt to short-circuit them, shortcut them by taking coercive steps of the kind that Ericsson has done. Finally then, my lords, on categorization. Learned friend says, well, there is no need to fashion some special form of order to deal with this case or cases of this kind. Put to one side the fact that categorization in relation to injunctions is itself something which, on the authorities, one should be wary of. We say, firstly, that we have a case on which it would be right to grant us relief on an entirely conventional approach, having regard to what we say about damages and what we say about the unconscionability of Ericsson's conduct. But if one wants to think in terms of categorization, what we have here is a distinct fact pattern which has emerged as a result of the fact that in Unwired Planet, the Supreme Court set out a framework which is now being, as it were, worked through by the industry. And the implications of that framework are being explored in a number of cases which are currently before the English courts. This is a distinct fact pattern insofar as we are concerned here with intellectual property rights, which are territorially limited, the exercise of those rights by parties which have accepted that they should be, by contract, derogated from in the full extent to which they might otherwise be exercised, and a growing body of case law which emphasizes the need to find a non-disruptive way in which the disputes which are inevitable under such a regime are to be resolved. This is a case which raises a novel fact pattern, but it is not one that is unique to this case, and it will be apparent to those who have been involved in this area of law and practice that the industries are struggling to find a way of operating fairly and reasonably, which is also consistent with the orderly determination of their disputes before these courts.
Yeah, well, that's because the standard-setting organisations refuse to adopt a rational policy, which is to have a global dispute resolution system. And so long as that is the case, the national courts are stuck doing the best they can. That's a well-known problem. There's nothing we can do about it.
Well, my Lord, I was endeavouring to nod respectfully until you got to the "there's nothing we can do about it" bit. Of course, there is, in a sense, nothing one can do about it, in the sense that unless and until those institutions take a different course or are obliged by any other supranational institutions so to do, it will be a matter for the courts to do what best they can. But it's not that there's nothing that these courts can do about it. There's something which this court can do about it, albeit only a particular aspect of it, in this very case, and we urge you to do so.
I think there might be a note.
Oh, yes. Yes. If you will indulge me very briefly. First of all, I offered to hand up, but then I was talking and I didn't hand up, the decision in the Interdigital Technology Corporation and the Novo case, the decision to which my Lord Justice Arnold referred. And if we may, we will get those to my Lords, perhaps when you have risen. Secondly, I'm reminded that I failed to deal with a point that was raised in relation to the nature of the offers that have been made and the possibility of adjustments following a court determination. Now, we have in fact offered to pay into court, I think, a figure which has been described, I think, by Mr. Justice Richards as a very substantial one, despite the fact that we say that we will be the net payee as evidence of good faith and to dispose of any issue as to whether or not Ericsson might be out of pocket. They say, well, they can't recognise those figures. If that's right, there's an additional hurdle that's being put here by Ericsson in the way of any sensible interim position. Because if insofar as it's appropriate for money to pass before there is a final determination of the terms of a FRAND licence by the court, the obvious way to deal with it is to say, well, you say the rate should be X, maybe we can pay you X or a proportion of that at this stage, and when the court determines what the correct figure will be, one will make an appropriate adjustment. But that's not being offered. That would, one would have thought, address any genuine concern here as to what their ultimate position may be or any prejudice to it. They say they can't recognise the monies unless they are paid without any qualification. But of course, they could have started their proceedings themselves many years ago if that was the concern. As a matter of substance, we say, it is clear that what is being pursued here is not legitimate from a commercial perspective. It is seeking to force us to pay their rates and avoid the need to have a determination as to whether they're fair and reasonable. Lords, thank you.
Thank you very much. Yes, Mr. Block, Mr. Tampin, thank you very much and your respective teams for your comprehensive submissions. We will reserve our judgments. They will be provided to you in draft for the usual limited purposes of which you're very much aware. And we would hope that once you've got them, you'll be able to agree the order, but if not, any consequential matters will be dealt with on paper. So thank you all very much.
Thank you, Lord.